I don't know, so, there he is. The table gonna be in the way.
Who's up first?
That's a prayer.
All right, court calls 2019-423 CR 21-124 State versus Tessa Marie first up for pretrial. Go ahead.
Judge, I've talked to Ms. Curry about some outstanding issues on discovery pertaining to the CR 21-124 case. I sent her a reminder email earlier this afternoon. In addition, we've had some other information that I provided to Detective King, who is the lead on this case, and waiting to find out the results of that information. Long story short, I'm going to request that this matter be set for an additional pretrial so that we can resolve those outstanding issues.
Mr. Woodwhite.
State is unopposed to Mr. Schmidt's request, Your Honor.
You think is 30 days sufficient, Mr. Schmidt?
I'm not sure, Judge. I know that we were waiting for 2 autopsy reports from Swifts, and I'm not sure whether or not Ms. Curry's had an opportunity to request those. I'm sure they're completed because it's been a minute. So I'd follow with her. We can start with the August 10th date in the hopes that all that stuff will be put to bed by then.
Okay, let's do that. We'll set Ms. Furthan for pretrial August 10th at 1:30.
That's all I have, Judge. May I be excused?
Yes, sir. Thank you.
Thank you.
Your Honor, do you have Mr. Crawford on Zoom?
I do not. I do not. I have no one on Zoom.
We have his defendant and using him.
Now, when I logged in, I saw a Michael that was there, but okay, he just logged back in. Now it says Michael J. Crawford, attorney. So I'm sure that he may have logged in and had to log out to put his name in there. So you have Mr. Crawford available. You have his client available.
Sir.
All right, Ms. Newton, come on up. Do you have anyone else that's available, Ms. Abraham?
Nolan, Mr. White has Jason Bolt up here for the plea.
I don't see Mr. Crawford, so let's go ahead and do that. Ms. Newton, if you'll just have a seat, we'll try to get you going in just a moment.
I'll get Mr. White.
All right, CR 21-107 State versus Jason Benjamin Bolt. Show that we're set for arraignment, but it's my understanding Mr. Bolt's going to enter a plea today, Mr. White.
That's correct, Your Honor. The terms of the plea are 66 days in the county jail. The state's proceeding under 1244B. There'll be a $2,500 fine. The DPS restitution, I believe, is $180, and then of course the reimbursement fee and court cost.
Court costs are how much? $290 or $270? It'll be on the front page of that judgment.
$270, Your Honor.
$270.
And reimbursement fee?
$70.
And any credit time towards the sentence?
66 days.
So it's going to be time served?
Yes, Your Honor.
Okay. All right, Mr. Bolt, I'm going to swear you in. Raise your right hand, please, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, put your hand down. Make sure you speak up loudly and clearly for me. You are Jason Benjamin Bolt, correct?
Yes, sir, I am.
Mr. Bolt, are you a United States citizen?
Yes, sir, I am.
Do you read, write, and speak English?
Yes, sir, I can.
Have you ever been diagnosed with any type of mental condition?
No, I have not.
Mr. Bolt, you're charged by indictment with a state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram. That carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC, and also carries an optional fine up to $10,000. Do you understand that full range of punishment?
Yes, sir, I do.
Are you pleased with Mr. Nolan White as your attorney?
Yes, sir, I am.
Do you feel like you've had enough time to discuss the case with him and have all your questions answered?
Yes, sir, I have.
Anything about the paperwork that you've read and signed that you do not understand?
No, sir, there is not.
And does your signature appear correctly throughout the documents, and you only signed once you were confident you knew what you were signing?
Yes, sir, that is correct.
All right, and you've heard Mr. White indicate to the court what the terms of the plea are, and that's what you're asking the court to approve today.
Yes, sir, I am.
If the court approves this plea agreement, then that would be pursuant to section 1244B of the Texas Penal Code, which would lower the punishment range to up to a maximum of 1 year in the county jail and a $4,000 fine maximum. Do you understand that as well?
Yes, sir, I do.
Mr. White, do you believe Mr. Bolt to be competent today?
Your Honor, I believe Mr. Bolt's competent. I believe he's entering this plea knowingly, intelligently, and voluntarily. I believe he's waived those rights contained in the admonishments, and that he's mentally competent and that he understands what's proceeding against him here today.
Thank you, Mr. White. All right, Mr. Bolt, understanding the range of punishment for both a state jail felony and a prosecution under section 1244B, how do you plead to possession of a controlled substance, penalty group 1 less than 1 gram?
Guilty, Your Honor.
Now, you're pleading guilty to that charge, Mr. Bolt, because you are guilty of committing that charge.
Yes, sir, I am.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir, they have not.
All right, the court will accept the defendant's plea of guilt at this time. Mr. White, any objection to states 1?
No objection.
States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Mr. Woodwike, will you give me a summary of the facts that support the plea?
Yes, Your Honor. On the date in question, Wills Point Police Department comes up upon a car that is parked in the middle of the road. The 2 occupants, one of which is Mr. Bolt and I believe his girlfriend, I don't have her name in front of me, are involved with each other. They began investigating the female occupant for driving while intoxicated and get consent from her to search the vehicle. They search and find a backpack, I believe, in the trunk with medicine bottles with Mr. Bolt's name on it, and find marijuana and 0.6 grams of meth.
Mr. White, any?
No, sir, that's accurate.
Okay.
Addition of fact.
Anything further from the state?
No, Your Honor, we would rest and close.
Mr. White, anything further? All right, then based on the evidence as presented, the court finds there is evidence to support this plea. Court will convict Mr. Bolt pursuant to the plea agreement under section 1244B of the Texas Penal Code. Court assesses, convicts him of the possession of controlled substance, penalty group 1 less than 1 gram, assesses his punishment pursuant to the plea agreement at 66 days confinement in the Van Zandt County Jail. The court awards him 66 days credit for the time that he has already served towards that sentence in jail. Court assesses a $2,500 fine, $180 restitution, $270 court costs, and orders him to pay $70 reimbursement fees. Mr. Bolt, whenever you're released, I want you to report to the Van Zandt County Courthouse. If you're not released until after 5, then the next business day, I want you to report. and meet with the court compliance officer so that you can make arrangements to pay what you owe. Failure to do that will result in the court issuing a warrant for your arrest. Mr. Bolt, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you be fingerprinted with the deputy, and then you'll be processed out.
Judge, if I might interrupt briefly, state is also taking into consideration unfiled misdemeanor DA 2020-0401. That's not reflected in the paperwork. It's not a filed case. I will close that and send a disposition shortly, just for the record.
Thank you, Mr. Woodwag. All right, we're adjourned in Mr. Bolt's case.
Thank you.
All right, let me see if Mr. Crawford's back. And I don't believe Mr. Crawford can hear me, so I'm gonna put him back in the waiting room. Who do we have next, Mr. Chair?
Mr. Adams is going over the plea with Levi Rogers at the moment.
Okay, so he needs more time. Do we have anyone else that's ready?
No, we just have Miss Newton up here.
Okay, I'll try Mr. Crawford again, and we'll let Mr. Adams continue to do his work.
That's our,
Mr. White, is your client coming?
Oh, we already played it.
Oh, you got it.
Mr. Crawford? All right, now can you hear me, Mr. Crawford?
Yes, Your Honor.
Okay, all right, court calls CR 21-134-135 State versus Shelby and Newton, and we're set for pretrial today. Any announcements, Mr. Crawford?
No, Your Honor.
Do you have any contested pretrial motions?
Not at this time, Your Honor.
Okay, court finding no contested pretrial motions filed or requested, the court will set this for a docket call, and that'll give counsel time to determine whether or not we're going to resolve this case by plea agreement, or if we're going to request a trial either by the court or by the jury. Mr. Newton, Mr. Crawford, do you have an offer on Miss Newton on both her cases?
I don't believe so, Judge.
And Mr. Woodwhite, do you know if an offer's been made or extended to Ms. Newton through Mr. Crawford?
Judge, this case is Ms. Curry's case. I am unaware if there is, but I will make notes that if we are going to make one, that one be made immediately to Mr. Crawford, so he can convey that prior to our next setting.
Mr. Crawford, do you have your calendar available?
Excuse me?
Do you have your calendar available?
Yes, sir.
Are you available on August 12th?
1 second. My paralegal's leaving.
They're just gonna have to come in by her phone because her internet's not going to come on.
You looking? 1 second, Judge. Thank you.
That's fine.
You know how technology is.
Yes, I do.
If your Waco jury trial doesn't go.
What time? What time would you like to do it, Judge?
Well, if Miss Newton's in custody, it would be set at 1:30. I do all my jail in the afternoons and I do bail in the morning. So it'd be set at 1:30.
Okay, 1:30, August 12th. Does that look okay?
Yeah.
Okay, thank you, Judge.
Okay. All right. So we'll set Miss Newton for August 12th at 1:30.
That's on both cases, right, Judge?
Yes, sir. Both cases, and it's also what I'll expect that day is some kind of announcement, either a plea agreement or a resolution by trial, a request for bench trial or jury trial. And if there's any, extenuating circumstances, then we can take those up at that time to consider a reset if needed.
Sounds great, Your Honor.
All right. Thank you, Mr. Crawford.
You kind of freezing up. I don't know if it's my end or what.
Yeah, and I think it's probably on your end. So I said we'll see you
Okay.
on August. We'll see you on August 24th.
August 12th?
I'm sorry. Yes.
August 24th.
No. I looked at the case below this one. August 12th at 1:30. Yes, sir.
So August 12th, Judge?
Yes, sir. August 12th. I'm gonna send a message to Mr. Crawford also. August 12th at 1:30. All right, who do we have next?
We have Mr. Adams with Levi Rogers for a plea.
All right, this is cause number CR 2191, State versus Levi Christian Rogers. And Mr. Rogers, if you'll just go ahead, I'm going to swear you in. Raise your right hand. Mr. Rogers, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, thank you, Mr. Rogers. You can put your hand down. And who's going to outline the terms?
I'll go ahead and do that, Judge. I've got it right here.
Thank you,
So,
sir.
Mr. Rogers is accused of state jail felony theft of property. The terms of the plea agreement are that punishment will be assessed under section 1244A of the penal code. He will be sentenced to 149 days in the county jail. He will be credited for time served in the amount of 149 days. There is a fine of $4,000, $290 in court costs, and $520 in restitution, or excuse me, reimbursement.
All right. So, Mr. Rogers, a few questions for you. Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, Your Honor.
And have you ever been diagnosed with any type of mental condition?
Well, I have, but I'm currently taking medication for everything. So I'm with the Andrews Center. I'm on my proper medication and everything like that.
Okay. Can you just briefly tell me what kind of medications you're on?
I'm on an antipsychotic called Risperdal and boost bars for anxiety. But other than that, that's all I take. I take it twice a day.
Okay. And so if you're currently on medication, do you feel like those medications are helping you have a rational understanding of the proceedings that are going on here today?
Yes, sir. Yes, sir. I'm
Okay.
completely aware of everything going on.
Good. Excellent. I'm glad to hear that. All right. Mr. Rogers, are you pleased with Mr. Adams as your attorney?
He did an excellent job.
Feel like you've had enough time to talk about the case with him, have all your questions answered?
Yes, sir.
Is there anything in that paperwork that you've read and signed that you do not understand?
No, sir.
And you've signed that paperwork in several places. Are you telling me that that is your true and correct signature?
Yes, sir.
All right. Mr. Adams, do you believe Mr. Rogers to be competent today?
Yes, Your Honor. In visiting with Mr. Rogers, I'm aware of his mental diagnoses. However, in visiting with him and discussing his case, it appears that he is lucid and he understands what we talk about, and he's been able to assist me with his defense in this matter. He's legally competent.
Good. Thank you, sir. I appreciate that. Mr. Rogers, you've heard the plea agreement announced by Mr. Adams to the court. If the court follows this plea agreement, you understand that you will be a convicted felon. You understand that?
Yes, sir.
And you're asking the court to move forward with this plea?
Yes, sir.
Okay. All right. So, Mr. Rogers, you are charged by indictment, a state jail felony offense of theft of property greater than or equal to $2,500, but less than $30,000. If prosecuted under Section 1244A of the Texas Penal Code, the punishment range would be reduced to that of a Class A misdemeanor, which would mean that your incarceration could not exceed more than 365 days in the county jail, and the fine cannot exceed $4,000. That is the range of punishment, and the court does find that the proposed plea agreement fits within that range of punishment. Do you understand both of those things, Mr. Rogers?
Yes, sir.
All right. So, Mr. Rogers, understanding the range of punishment and the plea agreement, how do you plead to that offense?
I plead guilty.
Mr. Rogers, are you pleading guilty because you are guilty of committing that offense? Reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right. Court will accept the defendant's plea of guilt. Mr. Adams, any objection to States 1?
No objection, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Mr. Woodwhite, can I get a summary of the facts, please, sir?
Yes, sir. Judge, on the date in question, September 13th, 2020, the defendant is pulled over for a defective taillight and is giving a warning for that, for a ticket for no insurance. During the stop, he tells the police officer that he is borrowing the truck, and the truck is owned by his uncle Doug, who owns Potts Feed Store. The next day, the actual owner of Potts Feed Store, Charles Smith, calls to report that his truck has been stolen. Subsequently, Grand Saline Police Department goes to Rains County, where the defendant was incarcerated at that time, not on this case, and he gives a full confession that he did indeed steal the vehicle from Potts Feed Store.
Any objection, Mr. Adams?
No objection, Your Honor.
All right, then the court, based on the evidence presented, will follow the recommendation and plea agreement in this case. Court hereby convicts Mr. Rogers of theft of property, $2,500, but less than $30,000. Will assess his punishment in accordance with the plea agreement and pursuant to Section 1244A of the Texas Penal Code at 149 days confinement in the Van Zandt County Jail. Court will award him 149 days credit towards that sentence for time spent in jail on this cause. Court assesses a $4,000 fine, $290 court costs, and $520 reimbursement fees. Mr. Rogers, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted. Once you are released, I'm going to order you to report to the Van Zandt County Courthouse so you can make arrangements to pay the money that you owe. Your failure to do so will result in a warrant being issued for your arrest. Do you understand?
Yes, sir. Am I going today to set up that payment plan, or do I need to do it tomorrow?
If you get out today before 5 p.m., it's
Okay.
o'clock right now. If you don't get out before 5 p.m., then just come tomorrow. If you can't and get here today, then come and meet with her today so you can take care of that business.
Yes, sir.
All right. Good luck to you, sir.
Thank you. Yes, sir.
All right, Mr. Adams, do we have Mr. Guzman Castaneda pulled?
We do, Your Honor, but I need the interpreter for Mr. Guzman, so as soon as he arrives, I can go over the paperwork with my client, and then we can have her here.
Well, okay, well, that's going to be a problem. if you haven't gone over the paperwork with your client yet, that's gonna be a problem because the interpreter's here now. But we don't have another device set up there for y'all to be in a breakout room. Patty, you want to see if anyone has that available that they can log in and I can put them in a separate room? We didn't bring that device because of the reasons we discussed, Mr. Abraham.
Okay,
I apologize, Your Honor. I thought the interpreter would be physically present.
No,
Deputy McLeish,
interpreters are only appearing via Zoom because they're paid for by the Office of Court Administration.
Deputy McLeish has her computer.
Okay. So I guess I'm going to need to ask the interpreter. I need to bring her in and ask her if she's going to be she may have only set us for a 15-minute time schedule. So if you'll go set that up, Ms. Abraham, then I'll speak with Miss Laura. Looks like Whalen, and find out if she's going to be available.
Okay. I like you to go to your name. Okay. Okay. Busy. Yeah. As always.
Yes. I just wish I realized that. I should come over to this. Come on. Cell phone?
No, it was spam calls.
Oh, yeah.
Everybody's worried about my warranty on my old phone, on my Medicare.
Don't worry about me too.
I'm telling you. No, none of that.
Here it is.
Hey, can we get Brittany Arnold up here, please? Thank you. Yes, ma'am. What's it?
Okay, so once Judge connects, do we have to do anything? Because he'll have done it on his side.
Hey, I'm like, what's going on?
They're gonna go in a breakout room, so they can go over
You're
the
going.
papers.
In Spanish? Okay.
The judge is gonna put them in a breakout room. I think he's talking to the interpreter right now, correct? Okay, and then they're gonna go in a breakout room and go over the plea papers. And then they'll come back in and we'll do it here.
We'll figure it out.
It's been a while since we've done it, so. Oh, no.
There's some leaps and bounds.
Oh.
Okay, cool.
Don't forget, Mr. Rogers.
Oh, you, are good with me?
All right.
Tell you what, let's,
Go for somewhere else.
yeah, we're gonna go back to mine. Yeah. I got things about housing, something Carl before he got out the last time around, as far as some kind of place.
Sounds like they think he needs a nursing home. I haven't been able to talk to Judge yet.
Okay. Yeah, I don't think there's any kind of easy answer.
Just one second. I'm still working with this interpreter.
Okay, well, Deputy Winfrey is taking him and Mr. Adams to a private room.
And I'm going to tell you that Ms. Wallen and I, we've been in a breakout room discussing this, and we are going to try the simultaneous interpretation.
Okay,
She says that she is familiar with that, so we're going to try it when we get back in. So, Deputy, yes, okay. So what I'm going to do, Aaron, is I'm going to send you an invite to a breakout room.
Okay.
And the interpreter is already there. So if you can get Mr. Adams in there and there he is. I see him now. I see him now. So, okay, so just accept that invitation. And then whenever you're done, Mitch, whenever you're done, if you'll just let Aaron know, then I will pull both of you back into the main session. Don't close out or anything. Just let her know or let somebody there know, and I'll pull you back in.
We're in the welcome area right now, so we'll just stay put after we finish.
Yeah, that doesn't look, I think that is a welcome area for some people.
Yeah.
And hey, Mitch, I'm going to tell you also, and speaking with the interpreter, she just asked that whenever we get to some of the like ranges of punishments and the sentence options and things like that, if we'll just make sure that we go a little bit slower on those things that are just not everyday language, to give her time to adequately and accurately describe that to the defendant. So we make sure that she doesn't miss anything. Okay.
Yes, sir. I'll take it easy on her.
All right. Please do. Be nice today. Awesome.
Yes, sir.
All right. So let me send you that invitation here.
Everything mine with this. The signal.
All right. Now for the rest of us, who's next?
okay, Mr. Sanders has arrived and he is going over the plea paperwork with Brittany Arnold. So at the moment, that's where we're at.
I assume that means Mr. Sanders is COVID free.
Hoping
Don't
so.
don't say don't say and two, don't say you think so. That's not good.
He informed me yesterday that he was 10 days out from his last fever, so he should be fine, Judge. It's the should be is why I'm over here and not over there.
Should
He
be.
said he is feeling better.
Okay. We're taking him at his word. He's working. And let's see. Anybody, what about Mr. White and Miss Kennedy? Are they still working on stuff?
To my knowledge, Miss Kennedy has not arrived.
She has not arrived. Okay.
Okay.
And let's see, Mr. Stevens, he said he was going to be late. So I've got that noted. He's trying to handle some things in Athens, I think.
And I'm not saying Mr. Manning.
So I'm sorry. So on Mr. Schoenfeld, we've already reset that. He requested it be reset this morning to July 29th at 1:30. There's some financial obligations that they're trying to get saved up before they can do the plea agreement. So we won't need Schoenfeld. So just Guzman, Kennedy, and then Mr. Sanders with Hansard.
And Arnold.
And Arnold.
Yes, Judge.
And then we'll wait on Mr. Stevens.
So Schoenfeld has already signed a reset form.
I don't know if he assigned a reset form or not. I'm not sure. Mr. Manning said that in morning session, so I don't know if he came out there or not. Probably best to go ahead and fill one out and send one back to him so that he does have it in his records and so that he knows. And you may note on there that his attorney requested the reset. He's probably aware because I think Mr. Manning spoke with him about the need to get the money up to do the plea agreement.
The 725 plea.
29. It's on that evidentiary docket on the 29th.
Okay. All right, well, we'll let you know when we're ready again.
Thank you, ma'am. I'll sit here patiently waiting.
Thank you.
you hear me?
I think he's gone. He's off the bench.
I don't think he ever leaves the beach.
Hey, I hear you. Judge is on his way in just 1 second.
Very good. Wayne, I just didn't know. I didn't know if we needed to stay in this room or if we needed to return to the conference room. Do y'all?
Okay, he's coming. He's coming.
Okay,
We'll stay put.
okay.
All right, are we ready to proceed on Mr. Guzman's case?
We're ready, Your Honor.
All right, give me just 1 second. Let me grab.
You still got the interpreter, I guess? Okay.
It's all up there. Bottom left hand corner.
We might have to do. Use the interpreter. We have a little globe at the bottom that we have to change the language for, and I don't see that. But we've also deviated from our normal routine today. So.
All right, let me get our interpretation set up. This one here. Just a Spanish. All right, Miss Wallen, I have enabled the interpretation on my side. I'm going to go down and click English. So that should put me in the English channel.
Yes. We're going to Spanish.
And Mr. Adams, I'm not sure, but I don't know that you can be in there with him. You may have to be out in the jail court because you may only hear
Spanish.
Speaking Spanish.
Okay, it's fine. Should I take this one?
Correct me if I'm wrong, Miss Wallen, but I think that you'll probably need to be in the jail court.
I'll get over there and look at his split, Your Honor.
I'll see you in there with him when we're done.
Okay. Thank you.
Yes, sir.
Sí, sí, lo digo. Okay.
Okay.
Quicker than I'll look.
All right, the court's going to call cause number CR 21120, State of Texas versus Juan Guzman Castaneda. And before I go any further, I am going to swear in Miss Laura Wallen. She is the court-appointed interpreter employed by the Office of Court Administration. Miss Wallen, if you'll raise your right hand. Ma'am, do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment? So help you God.
No la oigo nada.
Thank you, Ms. Wallen.
¿Y qué dice? Yeah.
All right, and he can put his hand down. All right, Mr. Castaneda, I've got several questions for you. Is your name Juan Guzman Castaneda?
Sí.
And Mr. Castaneda, are you a United States citizen?
No.
Do you read, write, or speak English?
Nomás leo y escribo en español, en inglés no.
And today you are being assisted by a court interpreter translating the English language into Spanish and Spanish back to English. Do you understand that?
Sí.
Okay. And do you understand, Mr. Castaneda, if I go forward with any plea agreement in this case, it could have an effect on your legal status in this country?
Sí.
And you're not a lawful permanent resident, is that correct?
No.
So at this time, you have no legal status in this country.
No.
And Mr. Castaneda, have you ever been diagnosed with any type of mental condition?
No.
And are you pleased with your attorney, Mr. Mitch Adams, who's been appointed by the court?
Sí.
Do you feel like you've had enough time to discuss your case with him and have all of your questions answered?
Sí, está bien.
And do you understand everything that was explained to you in the paperwork that you signed?
Sí.
And you went over all of these papers with your attorney, Mr. Adams, and you were assisted by Ms. Wallen, the interpreter, so that you could understand the documents. Is that correct?
Sí, así es. Sí.
And do you have any questions about the proceeding or the paperwork today?
No, todo está bien ya.
Okay. And Mr. Castaneda, I see here that the plea agreement is that you would be pleading guilty to an offense of driving while intoxicated with a child 15 years of age or younger, and that if the court accepted the agreement, the court would assess your punishment at 208 days confinement in the county jail. You would receive credit for 208 days of time served. You would also be assessed a fine of $1,100, $60 restitution, in order to reimburse Van Zandt County $520. Is that your understanding of the plea agreement?
Sí.
And you understand that if you are convicted of this offense today, that you could be deported from the United States?
Sí.
Mr. Adams, do you believe Mr. Guzman Castaneda to be competent today?
I believe he is legally competent, Your Honor.
And you did explain through the court's interpreter all of his legal rights, including all of the admonishments and waivers in the court's admonishments?
That's correct, Your Honor. I did so. Mr. Guzman acknowledged that he understood everything that we discussed.
Okay. So, Mr. Guzman, the range of punishment for this offense under Section 1244A of the Texas Penal Code is for a sentence not to exceed 365 days in the county jail or a fine more than $4,000. The plea agreement I see legally fits within that range of punishment. Do you understand both the range of punishment and the plea agreement?
Sí.
All right, so I'm going to ask you at this time, how do you plead to driving while intoxicated with a child under 15 years of age?
Culpable.
And Mr. Guzman, are you pleading guilty because you are guilty of committing that offense?
Sí.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court will accept the defendant's plea of guilt at this time. Mr. Adams, any objection to States Exhibit 1, the stipulation of evidence in this case?
No objection, Your Honor.
States Exhibit 1 is admitted in evidence, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state at this time?
Judge, I don't know if you have a copy of the stipulation.
Yes, I do.
Okay, no, stay as nothing further would rest and close.
Anything further for the defense, Mr. Adams?
No, Your Honor, we rest and close.
Okay, I'm going to take just a moment and review the evidence in the case.
Fee? Is that fee? No. Okay.
All right, Mr. Guzman, I've reviewed the evidence and I do find enough evidence to convict you of this offense. The court will follow the plea agreement that you've reached with your attorney and the attorney for the state. The court hereby convicts you of driving while intoxicated with a child under 15 years of age. The court assesses your punishment under section 1244A of the Texas Penal Code at 208 days in the county jail. Court will issue you credit for 208 days for time served. The court orders you to pay a fine of $1,100, orders you to pay restitution of $60, and orders you to pay reimbursement fees of $520 and court costs of $290. Mr. Guzman, when you are released, if you are released from the Van Zandt County Jail, then I'm going to order you to report to the Van Zandt County Courthouse so that you can make arrangements to pay the fines and fees that have been ordered in this case. Do you understand? And Mr. Guzman, do you have any questions about this proceeding today?
No, está bien.
Okay, so Mr. Guzman, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted. Good luck to you, sir.
Gracias.
You're welcome.
Judge, I think that's all I have on the court docket this afternoon. May I be excused?
Yes, thank you, Mr. Adams.
All right, thank you, Judge. Nice to see you.
Thank you, Aaron. I appreciate your help. You come to the rescue as always. Ms. Wallen, thank you so much for helping us out today, and thanks for doing the simultaneous for us. It sure does help. You're excused. Tell Leonard that I give you 2 thumbs up. All right. Yes, sir. Or yes, ma'am. Thank you. I'll do that. All right. Thank you. You too. Bye-bye.
Your Honor, we're ready with Jeff Sanders, 2 defendants. We're going to start with Ms. Arnold and her plea.
Okay. CR 21-5, CR 21-6, State versus Brittany Cheyenne Arnold. And what are the terms of the plea today, Mr. Sanders? And it's good to see you, by the way.
Good to see you, Judge. Thanks. She's going to be pleading guilty to CR 21-0006, and then CR 21-005 will be 1245. Then there are several other unfiled cases that will also be 1245 into this case.
Okay. And so what are
Let me go ahead and read that.
yes, if you will, if you'll just start with the offense and just kind of read through that plea agreement.
Okay. It's for a 4-year sentence to TDCJ and a $5,000 fine in cause number CR 21-00006. And then cause number CR 21.
Let's go back just a second. So on CR 21-6, 4 years TDC, $5,000 fine, court costs,
Yes, $290.
reimbursement fees,
$20.
credit towards that sentence.
270 days.
Okay. And okay. And so are these remaining cases you're about to announce all going to be 1245?
Yes, they are.
Okay. So give me the cause numbers. I see CR 21-5 that I've got that. What are the other ones?
Okay. And then there's DA control number 2020-1055. And that's a misdemeanor possession of a dangerous drug.
Okay.
Then DA 2020-1053, and that's a DWI. And then DA 2020-1056, which is an unlawfully carrying a weapon. And then DA 2020-1052, it's a fraudulent possession or use of credit or debit card. And then DA 2020-1050, it's an unauthorized use of motor vehicle. And then DA 2020-1054, theft of property value between 100 and 750.
My hand's starting to cramp. Is there more than that?
No, that's it. That's it.
Wow, Miss Arnold, you racked up a lot of charges. Okay, Ms. Arnold, raise your right hand. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you put your hand down. Your name is Brittany Cheyenne Arnold, is that right?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
Yes, Your Honor.
What have you been diagnosed with?
Borderline personality disorder, anxiety, major depression.
Are you on any kind of medication for those or undergoing treatment at this time?
Yes, sir.
Is it treatment or medication or both?
Medication.
Do you feel like that medication is assisting you today and making you able to rationally understand the proceedings today?
Yes, Your Honor.
Okay. And you do read, write, and speak English, is that right?
Yes, sir.
And Ms. Arnold, are you pleased with Mr. Sanders as your attorney?
Yes, sir.
Feel like you've had enough time to discuss all these cases with him and understand all your legal rights and have answers to all your questions?
Yes, sir.
Anything about the paper that you've read and signed today that you do not understand?
No, Your Honor.
And your signature as it appears in the paperwork, that is your true and correct signature, and you only sign once you were satisfied of what you were signing.
Yes, sir.
Mr. Sanders, do you believe Ms. Arnold to be competent today?
Yes, sir. I believe she is. I believe she understands the charges against her as well as the consequences of pleading guilty to this charge.
And you've explained to her all of her legal constitutional rights?
Yes, Your Honor.
All right. And Mr. Arnold, you heard Mr. Sanders read out the plea agreement in this case. Is that what you're asking the court to approve today?
That's what you're asking the judge to approve.
Yeah, yes, sir.
All right. right, so Ms. Arnold, in cause number CR 21-6, you are charged with the second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams, carries a range of punishment of not less than 2 years or more than 20 years, and a $10,000 fine. That's the range of punishment. And I find that the plea agreement proposed fits within that range of punishment. Do you understand both the range of punishment and the plea agreement?
Yes, Your Honor.
All right, so Ms. Arnold, how do you plead to that offense?
Guilty.
And are you pleading guilty because you were guilty of committing that offense?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this charge today?
No, Your Honor.
All right, court will accept the defendant's plea of guilt. Mr. Sanders, any objection to states 1?
No objection.
All right, states 1, stipulation of evidence is admitted. Court does take judicial notice of Ms. Arnold's judicial confession. Mr. Woodwhack, if you can give me a summary of the facts.
Yes, Judge. The Wills Point Police Department is called out on suspicious persons. If you recall, the co-defendant took a plea to this, I believe, last week. They are both passed out in the reporting party's driveway. Miss Arnold tells the officer during the investigation she's driving from Dallas to Shreveport to do a repossession. It took them about 6 hours to get from Dallas to just outside Van Zandt County, just outside Wills Point. So she got sleepy and decided to take the back roads. She then saw an abandoned house and went to the house across the street to inquire as to buying the abandoned house. But she passed out before she could get out of her vehicle to go to the front door. During the investigation, it comes back that the car has been reported stolen. And during the inventory, they find two firearms, 6.8 grams of meth, and some other property. I believe both Miss Arnold and Mr. Kronberger are both heavily intoxicated during these interactions.
Any objection to that summary?
No objection.
All right. Then based on the evidence presented, the court will find that there's enough evidence to convict Ms. Arnold of this offense. The court does follow the plea agreement in this case, convicts her of possession of controlled substance, penalty group 1, greater than or equal to 4 grams, but less than 200 grams. Assesses her punishment at 4 years confinement in the Texas Department of Criminal Justice. Orders her to pay a $5,000 fine, $290 court cost, $20 reimbursement fee. Court also awards her 270 days credit towards her sentence for the time that she has spent in jail on this cause. Court will take into consideration under section 1245 DA number 2020-150, DA 2020-1052, 1053, 1054, 1055, and 1056. Ms. Arnold, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. In just a moment, I'm going to have you be fingerprinted with a bailiff. Once you are released from TDC, I'm going to order you to the Van Zandt County Courthouse so that you can make arrangements to pay off the fines and fees. We don't expect you to pay those all at once, but we do expect them to be paid. If you fail to report, fail to make an effort at paying those, then unfortunately we'll have to issue a warrant for your arrest and you'll be right back in the same situation you find yourself today. Do you understand?
Yes, Your Honor.
Ms. Arnold, have you ever been to prison before?
No, sir.
How old are you?
25.
25? Do you have children?
Yes, I do.
How old are your children?
She's about to be 2.
About to be 2. Well, you may get a chance to get out of prison and clean up your act before she knows what's happened. But if you don't do that, how sad it would be for your daughter to be growing up while you're in prison and knowing it. So when you get out, you're going to have a choice to make. either choose a life that's going to be honorable and productive and beneficial to you, your family, and everyone around you, or you can just be property of the state of Texas for the rest of your life. That'd be pretty sad in my book.
Thank you, Your Honor.
You're welcome. Good luck to you. Go get fingerprinted. And when you get out of prison, just come pay those fees. Mr. Abraham, who's the next contestant?
Mr. Hansard.
Mr. Hansard, come on down. CR 20-339. Norman Wayne Hansard set for pretrial. Go ahead, Mr. Sanders.
Judge, we don't have any pretrial issues. This is a case I'd been appointed on, I believe, substituted in for another attorney back in May, but we don't have any pretrial matters to address. He's asked to have a separate docket call.
Have you spoken with Mr. Woodwike? I believe we did a motion to suppress in this case. Mr. Woodwike, have you brought Mr. Sanders up to speed on the brought by Mr. Gimbel and the court's ruling?
Judge, I have not spoken to Mr. Sanders regarding the issues that were brought up by the former counsel, but I would be happy to discuss that and further plea negotiations with him in short order.
Okay, yeah, I would ask that you do that just to bring Mr. Sanders up to speed so he understands what Mr. Hansard, learned during the hearing. And if you need anything from the court with regards to that, Mr. Sanders, let me know, and I'll be happy to do that as well. But it's easier to have you and Mr. Woodwike speak rather than me, you, and Mr. Woodwike, have to be scheduled. So
That'd be fine, Judge. Thank you.
okay, we'll set Mr. Hansard then for a docket call. Mr. Sanders, what does your calendar look like for August? Are you available on August 12th?
Yes, that'd be fine.
Okay, we'll set Mr. Hansard then for docket call on August 12th at 1:30.
Thank you, Your Honor.
You're welcome, sir.
Stevens needs to talk to him, and I told him to go ahead and bring this off the papers. I don't think we'll tell him to show.
Correct. Candace Smith waited.
They're on their way.
Yes, ma'am. Ms. Kennedy arrived yet?
No, sir. We have Candace Smith coming up for Mr. Stevens, and we have Justice Wakeman, the habeas profile, on his way. Mr. Stevens needs to speak with Ms. Smith for just a short time. So Mr. Wakeman is in the room now.
Okay, I do have a TRO set at 3:30. So if we're not resolved on the criminal case, they may have to wait. So just let them know. And the TRO is set for an hour.
He said he just needs about 3 minutes.
Okay.
Sure.
Mr. Wakeman.
Oh, I'm sorry. Okay.
Mr. Wakeman, I see here that you are incarcerated on a couple of things. The only thing regarding Van Zandt County is a two charges of capious profile from charges of burglary of a building.
Yes, sir.
I see here that you owe $3,313 in one case, $1,709 in another case. And you also $54, about $55 in restitution. Are you able to discharge these so that you can be released from jail?
I can't afford to pay now, sir. I can pay payments. So now that I get one of those, my wife gets a check. She told me she helped me pay for it, but that's the only way I can pay for it. Like payments. I tried that one time, but man, I kind of got onto drugs real bad. But I had another kid now, and I've been doing a lot better with my life. And I haven't been really getting in trouble. So marijuana charge I got in Smith County. I mean, Van Zandt County now trying to tell me it's a cash bond. So I don't know.
You're also being held on Cherokee County charges, right?
That's what I was talking about, the marijuana charge. I can afford it. I can afford to pay every 2 weeks.
How come you weren't paying every 2 weeks before when you were out?
I didn't have a job or anything, and I was just.
Why didn't you have a job?
Because nobody wants to hire me. I got tattoos on my face. And I can't read and write and stuff. I have seizures, so I'm supposed to be getting on my government check.
You regret those tattoos on your face now?
Yes, I do, big time.
Yeah, I bet so. I think that would be hard to live with. So you're telling me if I let you out of jail, you can pay every 2 weeks?
Yes, sir.
How long have you been in jail?
Just a couple of days. 2 days, I think now. I'm just trying. All I know is they were talking to me about another thing that happened. They weren't even supposed to take me to jail. I get in the vehicle with Pat Jordan, and they could get a call in talking about a lady who was unresponsive with her 2 kids, and they didn't even get tell. I didn't even get to tell my babies bye or nothing. I just walked out on my kids, and I don't think it's right they done that to me, because they were talking to me about a totally whole different situation. Not even this situation coming up. And I haven't got no letters in the mail stating that, that y'all supposed to arrest me on these charges, or I'd have probably came up here and tried to make a payment plan myself. I forgot really all about it, to be honest with you. Because I've been in jail like 3 or 4 times since then.
Yeah, I understand, but I mean, you knew you owed them.
Yeah, I didn't know that, and I should have done it. It's being young and dumb. It's my problem. But now I'm trying to get my life straight because I got my 2 kids. I just have my little girl too, especially. I just don't want to lose them. My wife's told me, I've been with the same woman for 10 years. She told me she's ready to leave me if I don't get my stuff straight. And I don't want to lose my kids over some stupid shit. Excuse my language. Over some dumb stuff.
Are you going to make bond on the Cherokee charges?
They say it's cash bond.
Well, one's a release of surety, and
Sorry?
I don't think that you can be required to post a cash bond.
You don't think so? I didn't think so either.
Well, the law says you can't mandate that it's cash. So, but what would happen is if I let you out, then you're going to be sent back to Cherokee County unless you make.
I'm just trying to get it over with so I can get over there and get a bond.
All right, Mr. Wacom, I tell you what, I'm I'm going to let you out. I'm going to give you credit. I'm going to give you some money credit for the couple days that you spent in jail, but I'm going to let you out. And as soon as you get out, I want you to get over here to the courthouse and start. I want you to make a payment, and I'm going to give you about 30 days, and we're going to see how you do. If you don't do good, then I'm just going to issue another warrant, and we're going to bring you back. And we'll just keep on doing this until we get paid off, and it won't be good for you to be trying to get a job and get rearrested and losing it. You understand?
Yes, sir. I thank you very much.
All right, I'll send some paperwork out there in a little bit.
Okay, Mr. Stevens is ready.
Okay. All right, CR 2368, State versus Candace Kaylin Smith. Go ahead.
Because we're set for docket call today.
Yes, sir.
And the state has made my client an offer. I've discussed it with her. She tells me that she's going to take the offer. We don't have plea papers up today, so we have to set it for a plea. But I think she wanted to ask the court something, Your Honor, if you want to let her ask.
I'd rather you ask it for her, Mr. Stevens.
Judge, she wrote a letter to the court, and she just wanted to know if the court had received a letter that she wrote.
I don't know. I received lots of letters from lots of people. So when did you write it?
Last week.
Last week, Your Honor.
And what's it about?
Asking for the
Judge, she's writing a letter to the court asking for Bowie Women's Center, some kind of a rehab probation type thing. So her letter's about.
Well, I typically don't read letters from inmates because it's a pending case and it would be considered ex parte communication. So usually I have my criminal court coordinator, Ms. Taberham, intercept those and send that to counsel and to the state. So I can tell you I have not read that. So if that's something that you want, you should communicate that to Mr. Stevens, who can communicate that to the DA's office.
Your Honor, just to make sure we all understand each other. The prosecutor's office, they're not offering probation. They're never going to offer probation. My client had talked about rehab. I discussed with her that we could go open to the court, but I think she's a little reluctant to do that and told me just minutes ago that she'd rather go ahead and sign for the 12-month state jail. No, is that correct what I just told you?
Yes, sir. So I'm ready to just do something.
So what we're going to do, Judge, is ask for a plea date. So.
Well, and I understand, Ms. Smith. It sounds like you want me to tell you whether or not I would give you rehab, and that's just unfortunately not how it works. If you wanted to go open to the court and plead your case for rehab and have Mr. Stevens present that, then that's a risk that you would take, and that's the way you do that. Okay, so if that's something you want, you'd have to go open to the court and then come and present evidence as to why I should do that. And the state's going to have their opportunity to present evidence as to why they think or don't think that that's a good idea. Okay, does that make sense?
Yes, sir. I'll just do the 12 months.
We're going to go ahead and enter a plea of guilty, Your Honor, for the 12 months. We'll get a new court date, get plea papers in.
All right. Can you be available?
She actually wanted to do it today. I explained to her that we couldn't do it today because no plea papers have been done.
Yeah.
We couldn't do it this afternoon.
Can you be available next week, Mr. Stevens?
What day, Your Honor, sir? Judge, I think you scheduled me in here for Friday afternoon anyway. I'm sorry, not Friday, Thursday the 15th. I think I'm on here at 1:30.
I believe so.
Yeah, I think we could squeeze you in.
Okay, great.
So let's set her for Thursday, the 15th.
May we be excused, Your Honor?
Yes, sir. Yes, sir.
Good
Thank you.
afternoon.
Any word on Ms. Kennedy?
I believe Mr. White is entering the room.
Mr. White is entering.
Mr. White is entering the room.
Mr. White has entered the room. Talk to me.
Judge, my client is supposed to be here. My assistant has called her. She said that she had just got to 19 and 20. So I'm assuming that she'll be here in the next couple of minutes. We'll get her
Okay.
taken care of.
Okay.
She's going to be taken into custody today.
Okay. I do have a TRO set at 3:30 with Mr. Paul Elliott. So if that requires a hearing, that's going to go 3:30 to 4:30. So if she's not here and we're ready to go before that time, then we'll just have to, we'll have to resume after that at 4:30.
I understand, Judge.
And so I'll stick with you if you'll stick with me.
Yes, sir.
Okay.
Thank you.
You're welcome. So I'll just stand in recess until I hear back on this.
Will I be able to see him again?
Judge Martin, are you there?
I'm always here, Dr. Mark.
Ms. Kennedy's here. They are ready to go, sir.
Okay. All right, this is cause number CR 1959, CR 2171, CR 2257, State versus Melba Renee Kennedy. Ready to go forward with the plea, Mr. White?
Yes, sir, we are.
Okay, can you outline the terms of the plea for me?
I can, Your Honor. In exchange for a plea of truth, the state is going to offer or recommend 4 years in the Department of Criminal Justice, $2,500 fine, $363 court costs, $360 of restitution, and is going to 1245 CR 2257, CR 20171. Would the court like the misdemeanor causes or just what kind of cases they are?
Just give me the numbers, be fine.
M 1900935, M 1900927, and DA 2020-0031. And Your Honor, Mr. or Miss Kennedy will have 11 days credit towards her sentence.
All right, and is she going to be bidding true to all the counts in the state's motion in CR 1959?
That's correct, Your Honor. And at this time, we'll waive formal reading of the state's motion to adjudicate. We've gone over it. We're aware of what the allegations are, and Ms. Kennedy intends on entering a plea of true to each and every allegation contained therein.
All right, thank you, Mr. White. Ms. Kennedy, if you'll raise your right hand, I'm going to place you under oath. Ms. Kennedy, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Give me just 1 second. I'm going to pull up the state's motion. All right, Ms. Kennedy, you appeared before this court on May 2nd, 2019. You pled guilty to possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, less than 4 grams, a third-degree felony, which carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice. Court heard the evidence that day, convicted you of that offense. I'm sorry, the court did not convict you of the offense. Rather, the court deferred a finding of guilt in that case and placed you on deferred community supervision for 5 years and assessed a $2,500 fine. It was during your term of community supervision that the state filed its motion to adjudicate and revoke, and they alleged in 13 separate counts various ways that you violated. Have you had enough time to review that motion with your attorney, Mr. White?
Yes.
Are you comfortable that you've had all your legal questions answered and you understand everything that you've read and signed?
Yes.
And are you pleased with Mr. White's representation of you?
Yes.
All right, and Mr. White has waived the reading. So I'm going to ask you at this time, Ms. Kennedy, as to counts 1 through 13 alleged in that motion, are those counts true or not true?
True.
True. And I can show them to you. Do you want to see them?
No.
No? Okay. All right. Then, Ms. Kennedy, has anyone threatened, forced, or pressured you to plead true?
No.
All right, court will accept the defendant's plea of true at this time. Mr. White, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No, sir.
All right, State's Exhibit A is admitted. Court does take judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we would rest and close.
from the defense? All right, then based on the evidence, Ms. Kennedy, I find that you have violated the terms and conditions of your community supervision. I find counts 1 through 13 to be true. The court adjudicates your guilt this day, convicts you of possession of a controlled substance, penalty group 1, greater than or equal to 1 gram, less than 4 grams. Court assesses your punishment in accordance with the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Awards you 11 days credit towards that sentence for time served in this case. The court also assesses your fine at $2,500 or orders you to pay financial obligations previously imposed, including fine, court costs, and restitution. The court does take into consideration and dismisses cause number CR 20-171, CR 20-257, M19-00935, M19-00937, and DA 2020-0031. Ms. Kennedy, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go with the bailiff to be fingerprinted. Once you get out of prison, if you've not paid off everything that you owe, Ms. Kennedy, I'm going to order you to report to the Van Zandt County Courthouse so you can make arrangements to pay what you owe. Failure to do that will result in the court issuing a warrant for your arrest, and you'll be right back here where you are today, okay? You understand?
Yes.
Okay, all right, good luck to you. Thank you, Mr. White.
Thank you, Your Honor.
You're welcome, sir. And am I also supposed to be handling Mr. Carlton Mitchell at all? I had this laying on my, is this a capias or something? It doesn't show to be a capias. It shows a couple of arrests.
That was one on the docket this morning that was in Smith County.
Oh, he was in Smith County? Okay, that's probably why I didn't recognize him. All right, I believe that concludes this for this afternoon.
All right, thank you, Your Honor.
Thank you all, appreciate it. Thank you, Aaron.
Thank you, Your Honor.
You're very welcome. Mr. Woodwike, good job being solo today.
I do my best, Judge.
Well, you did a great job, man. Appreciate you, buddy.
Thank you, Judge. We'll see you later.
Have a good day.
So did they paint that courtroom?